Well, the problem with this about talking about estate planning is really there are an awful lot of things that we deal with that people don't think to ask about. There are kind of some assumptions they don't. I kind of call it an RIQ, rarely asked questions. So what I'd like to talk about here is, to start with, is the top 7 misconceptions, things that a lot of people assume are true and rarely think to ask about. So, number 1 is, my spouse died without a will, so I automatically inherit everything. Many people assume that because they can usually access bank accounts and live in the family house after their spouse has died. Nothing needs to be done legally. And then 30 years later, the surviving spouse dies, and their family finds out the first one is still on the title of the house. And by the way, he had a child from the previous marriage whom no one can locate. And that child and the 6 other children all own half of the house, regardless of what the will of the surviving spouse says, because nobody thought to probate it. Title of the house and other property does not automatically pass for a surviving spouse. The second one, this is actually 1B, not 2, that's why we have 7. Says, I called the appraisal district. And the title is in my name because that's where I get the tax statements from. Well, I'm afraid that's just not true. Basically, the appraisal district in Collin County or Dallas County or wherever, all they really care about is who's paying the taxes. It has nothing whatsoever to do with who has actual title to the property. So number 2, it says 3 there. If I want to disinherit someone, I need to leave them $1. I see this all the time in wills. And number 1, it's not true. And number 2, it always causes more problems than it solves. Because if you think about it for a second, what you're doing is taking somebody that might otherwise not be part of the probate process and turning them into a beneficiary. In fact, they've got to get notice of like the will and the order probating the will. And you might want them to sign off on things because they're named in the will. Well, if they're getting a whole $1, they're not going to be all that happy about cooperating with anything. And so it's actually worse than giving them nothing at all. In the state of Texas, you do not have to leave your heirs anything. If there's somebody you want to disinherit, what you do is you say, it is my intention not to make any provision for this person in my will. You do not want to go into details that just causes complication. Now, another thing I'll point out about that issue is that in some states, like in Louisiana, there's a statutory share. So, it's important if you're going to leave somebody something, to leave them enough to where they're motivated to at least cooperate. At least a few $1,000s or something like that, where they can say, I'm not happy I didn't get my full share, but okay, it's worth me doing something about this. Number 3, the will names me as executor, so I can go ahead and handle things. A lot of people think that. Oh, I've got this document here, and I can show it to somebody, and I'm named as executor. Unfortunately, unlike, say, powers of attorney, a will is not legally valid and enforceable until it is probated. That's why it's important. The court has to accept the will and authorize the executor via letters testamentary to act on behalf of the deceased. 4, mom has a trust. She had a trust, so when she died, everything went into the trust. Not necessarily. Trusts are very useful, and we'll talk about them in a little while, but to be effective, they need to have property placed in them during their lifetime and properly transferred. They don't just automatically get things upon death unless it's set up. If that is the case, then you still will have to probate the will and make sure the property goes into mom's trust to make it effective. Okay? Number 5, now that dad has died, it's our house, right? We have the right to tell our stepmother she needs to move. A lot of people don't know that there is a constitutional right in Texas for a surviving spouse to live in the family house, even if it's dad's separate property and she has no ownership interest in it. She has a right to live there during her lifetime. And number 6, mom told me she wanted me to have her jewelry so her wishes need to be honored, or something similar to that. Sometimes it's oh, mom wanted me to do this, or mom wanted me to do that. The problem with that is that unless it is in a properly done and probated will, none of that has any legal effect and simply causes arguments among heirs. Even a notarized document, this is kind of a sub thing. A lot of people say, hey, I've got this document I've signed and it's notarized. No, that doesn't qualify as a will. I'll talk about the requirements in a little bit. And 7, we do not have a lot of money or property, so we really don't need wills or trusts. We don't have much. Frankly, these are the most frustrating situations I run into, and I run into them often. People often do not think planning is necessary, and after mom and dad pass away, you find that they're intestate. Intestate means without a will. Heirs are 11 siblings, 3 of whom are deceased, leaving 5 grandchildren, some of which are minors, and all of whom have to be brought into an heirship and administration proceeding to deal with their house, which is worth maybe $100,000 for everyone. And it will cost thousands and thousands to jump through all the legal hoops to get this property into an administration, sold, and the proceeds distributed to the heirs, because there are all sorts of safeguards in the estates code that have to be observed. And most often, nobody has the funds to pay for it. Had mom and dad sign proper, simple wills, the probate would be quick, easy, and efficient, and their beneficiaries could get the benefit of the house. Now, these situations can be an enormous mess. I tell my clients that in terms of their money, honestly, you don't really owe your heirs anything. You can give your money to your cat, as far as I'm concerned, but what I think you owe your heirs is not to leave a mess to clean up when you die. You know, we all understand that one of the most traumatic and difficult things we go through in our lifetimes is dealing with the death of a loved one. And adding legal difficulties on top of that takes the stress level up to 11 and can create permanent rifts in a family, and I've seen it happen. So let's see how we can avoid that and how to set things up so your estate is handled the way you want. Now, during this little talk, when I'm talking about what happens with or without a will, what we're really talking about is what happens with or without a will or a lifetime trust arrangement in place of a will. To save time, I'm just going to call it a will for now, and we'll discuss trust a little bit later. Estate planning really concerns only one thing: how property will pass and be distributed and managed upon one's death. Even lifetime trusts, though there may be other reasons for establishing them, are directed to that goal. That is, one are probate assets that pass through state law, rules, or through a will's directives, or non-probate assets which pass through different rules altogether. The most obvious examples of non-probate assets are things like insurance policies and employee benefits, which are distributed according to a contract. Even if you have a will which says, I give everything to my cousin Waldo, if your life insurance policy names your cat Cream Puff as the beneficiary, Cream Puff gets the benefits. The same holds true of an employee pension or stock benefit plan. Another example of non-probate asset is any property held in joint tenancy with right of survivorship. This is true of most joint bank accounts, which you'll find out by checking your signature card, and of many investment accounts. Although for federal estate tax purposes, this would all be considered part of your estate, under state law it passes outside of your estate and cannot be affected by a will. There are, of course, ways around this, as in the case where you decide to make your estate the beneficiary of your insurance policy, for example. So, if you die without a will, intestacy law, for your probate assets and what will happen to them, the fact of the matter is that if you don't have a will, the state of Texas, through this estates code, will determine what happens to your property. Of course, this is under intestacy law, which, as I said, simply means without a will. In case you don't leave a surviving spouse, it's pretty simple. Everything goes to your children, if you have any. If you don't have any children, it all goes to your parents. If one or both of your parents do not survive, that goes to your brothers. That share goes to your brothers and sisters. And if none of your brothers and sisters survive, then to your relatives. And it can get really complicated if you're going up to grandparents and off to first and second and third cousins, but it has to be calculated. So that may not seem all that simple after all, but it actually gets a lot more complicated if you leave a surviving spouse. In that case, you have to figure out what in your estate is separate property and what is community property. Separate property is what you brought into the marriage or you got afterwards by gift or devise. Community property is everything you acquired during the marriage, including your income. These things are divided up differently according to the surviving spouse. Obviously, since community property is one half the husband's and one half the wife's, the surviving spouse gets his or her half. That's obvious. But the property left over after that share is divided up, fractions can get pretty complicated, especially in blended families. So most people, when asked who they'd like to have their property when they die, would say it should all go to their surviving spouse and then to their children. The important thing to know about Texas intestacy law is that it simply won't work out that way without a will. The state of Texas will divide up your property according to the estate's code. Now, in many, if not most cases, that's probably not the way you'd like things to go, and yet, believe it or not, 70% of the people in the state of Texas die that way, without any planning at all. Your money can go to your heirs, but it will go through have to go through an administration that's going to be a lot more expensive, complicated, and time-consuming. So, just as an example, not long ago, a client came in with a problem. A widow owned a small house worth $80,000 that he wanted to buy. He was a real estate investor. The day before closing, he came to me with a problem. Her husband had died in 1984 and was still on the title. I told him, there's no way you're closing tomorrow, okay? It's just not happening. Some months later, he came back to me and he said, oh, they found out that the husband had 4 children from a previous marriage, 3 children with the second wife, 2 of whom were adopted out as babies before the marriage, and 1 of whom was also deceased. I had to inform him, but you're looking at a minimum retainer of at least $5,000 for somebody to start working on this thing, because it's really complicated. And it would likely cost double that, at least, to get it all figured out. And, of course, no one had any money to spare. The widow was trying to sell the house so that she could get some money for her long-term care. And, to be honest, you know what happened? I don't know what happened there, but probably the house may wind up being foreclosed on for unpaid taxes in some years. This happens with people in small estates quite frequently when it's just not economically doable to make sure property is transferred. So let's see how we can avoid that. The first big advantage of a will, which we probably don't hear about, is actually minimizing expense. We hear a lot about avoiding probate as if it's some kind of disease, but the only way that saves your heirs money is if there's planning in place of probate. When there's no planning, expenses mount rapidly. Now, as a probate lawyer, I don't mind these cases so much. I have to spend a lot of time on them, and I have to charge for my time. But honestly, in every case, I always find it a terrible waste. It didn't need to be that way. Also, under a will, of course, you can gift particular property. Even though you're single, you might want someone to have your baseball card collection, remember you buy, or you might want somebody to take care of your pet parakeet. And that's the simplest and most obvious reason for a will, which we can all relate to. You want to have a say in what happens to your property. When you do have a will, you delegate to one person who's called your executor the power to handle debts, collect claims, collect and sell assets, and handle any distributions necessary. As I said, when someone does not have those powers, it gets much more complicated and much more expensive. Your executor can be given the power, now this is something a lot of people don't know, your executor is normally given the power to manage your estate and distribute your property independent of court supervision. That makes things a lot easier to handle in almost all the states that are properly set up. Many people think, and also, many people think, hey, no one would want to fight over my property, especially not my family. Everything becomes different when somebody dies. You never know how someone will react to bereavement. And frankly, I've heard again and again, I cannot understand my brother or sister or cousin is acting this way. But I like to try to, I don't think people are bad, I don't think people are necessarily greedy, but some people just react that way in an estate situation. That's how they're dealing with someone's death, is grasping on the property. That's all they have. And it can become very difficult. So there are a few other things you can do with a will that are worth considering. For a will with couples with children, this is the most common situation. And I like to think about, I always like to have to look at worst case scenarios and say, let's make sure this is taken care of even when it's unlikely. So simultaneous death. What happens for a couple with children that have minor children? What happens if they're both hit by a bus at some point and their children need to be taken care of? Well, so sure, you may have life insurance, you may have assets, to go to your kids, but who would collect all of this and manage it? Who would manage and distribute your property, and above all, who would take care of your kids? First thing to think about is guardianships. Somebody needs to be appointed or named to take care of your kids. That can be done either within a will or in a declaration of guardian for minors. And you name a person or persons who you'd like to take care of your children. And of course, with the finances, you also want to provide for something to take care of your kids with. Now, that goes to a children's trust. Most people, when considering how to provide for their children in the best way possible, would like some say in how the money they're leaving their children is spent. You would ordinarily do this by creating a trust in your will, which would direct the trustee, who's the person who would manage the property placed in the trust, to distribute funds only in specific ways and for specific things. Often the trustee and the guardian may be the same person. They can be as specific or as general directions as you like. Now, most of the rules I draft have some provision like this in them, because that kind of a trust can provide your children with almost everything you would want them to have: education, opportunities, a concerned trustee and guardian. Almost as if you've been there to give it to them. Of course, this is not what happens most of the time. Most people live a little bit older. Most people don't die in simultaneous bus crashes. But even in the more ordinary scenario, you might want to think about providing for the surviving spouse in a marriage. It's obvious that the loss of a husband or wife is a terrible blow. What many people don't like to think about is that the loss of your spouse can also mean the loss of his or her income. That too can be a difficult blow. The surviving spouse is left with the inevitable expenses associated with death, funeral expenses, and often enormous medical bills. Usually this can be taken care of by insurance proceeds, but after those bills are taken care of, the loss of income still hurts month after month. Also worth considering is, as with the kids, the effect a large sum of money distributed all at once might have, depending on your situation, it might be wise to provide for some management of that money instead of simply giving the sum outright. You may have seen in the news how there are quite a few con artists, for instance, who prey on elderly people, or often widows or widowers. Many elderly people, all by themselves, with a large lump sum of money in the bank, are easy prey for swindlers, or persons selling poor investments of really questionable value. In this case, a marital reduction trust or a Q-tip trust can ensure that your surviving spouse, at the very least, has some assistance and guidance in managing the estate he or she is left with, and that the amounts needed to take care of the surviving spouse can last a long time. Second, the idea of providing a trust for your children still holds, because if the surviving spouse then dies, we have to consider the same things we did when preparing for both spouses dying at the same time. The surviving spouse may leave behind minor children who need looking after, but even if they're not minor children, if they hit the age of 18, I think most of us would look at our kids and say, it probably wouldn't have been a good idea to just dump a whole bunch of money in their heads when they turned 18. You can set up some longer provisions to provide for their education, their health, education, maintenance, and support until the age that you decide that is best for them. Now, one thing, the estate mentioned about minimizing estate tax also. Right now, as you may be aware, the estate tax is only applicable to a very small percentage of estates. In fact, our individual exemption amount is $12,060,000 per person. Not too many people, myself included, really need to worry about that sort of thing, but I will say that there are several proposals before Congress right now to drop that dramatically, because they really, really want to get some more money out of the estate tax. So it's something that is maybe not immediately applicable, but it might be in the near future we might need to think about. those things by saying set up a marital reduction trust for the benefit of the spouse to take full advantage of the state tax exemptions. That would be when I'm talking about the bypass or the credit shelter trust. Other techniques you can use are lifetime gifts and to minimize estate tax issues. But in fact, I think Cheryl just was talking about charitable trusts. What she didn't mention was they're a nifty technique because you can actually get an existing income tax deduction for setting up such a charitable trust and retaining the use of the money for the rest of your life. It's there's an annuity type calculation involved, but a lot of people don't think about that, and it can be an advantage versus just having to give it at the end of life to where you don't necessarily need a tax deduction for estate tax anymore. So, I'll move on to charitable planning. Gifts of qualified funds is another point that might be worth considering. A lot of people don't think, again, we don't have to worry about estate tax too much these days. We might in the near future, but not right now. What we do need to think about, though, is that a lot of us have things like IRAs and 401ks and pension plans that in fact can be most of people's estates. And you know what? That is subject to income tax now or later. It doesn't matter whether the estate tax applies, but your kids, if both of you die, are going to have to pay income tax on that, and oftentimes in a lump sum at a much higher rate than they would otherwise. A nifty way, if you are in a position to do this, is thinking about gifting some of those qualified, that qualified money to a qualified charity like the Catholic Foundation, because they have an exemption. They don't pay tax, and so what you're doing is getting a whole lot more bang for your buck on these funds. So that's a nice technique. That's the lifetime charitable trust. Now, one thing I like to talk about, we've also, we've talked about, yes, we need a will in place, and a lot of people look at me and say, well, sure, I need a will in place, but why can't I just write my own will? I got it, right? There are several books on the market, right? And we've all seen those ads for LegalZoom. I mean, that's just exactly the same as having an attorney, and it's cheaper. Well, the thing about those is, honestly, it's every time I run into this, it's easy to get something just barely wrong. Now, I'll start with, as an example, it's perfectly legal to write your own will in your own handwriting. Okay, it's just as enforceable as any will drawn up by a lawyer. It's a lot easier to call into question and have its validity challenged, though. And my favorite example is one I learned way back in law school. It's about a fellow that had a really nice, estate in California on the side of the mountain. And he called it Cragthorne. He loved it so much that he had a little stamp made up, Cragthorne, and he would send letters with Cragthorne at the top. And he wrote out his own will in his own handwriting. And he said, and he actually listed the full legal description of that thing. You know what I mean? The meets and bounds, walk this way and hit an iron spike and go that way. And he had it all completely nailed out down in his handwritten will. He left it to his son. Except he couldn't resist. He couldn't help himself. He said, also known as, and then he took his stamp and went, Cragthorne, and wrote it out and signed it. The court threw the will out. It wasn't a valid will. It wasn't all in his handwriting. And so he had to go through the test. See, it didn't go to his son and was a big mess. Now, fortunately here in Texas, our laws are a little bit more sensible. That probably wouldn't have been thrown out in Texas. But it's a fun example of how things can just go slightly wrong that you just never heard to. So, the other aspect of this is then proving it up in court. Even if you do write an effective and enforceable will, in order to get it admitted into probate, your executor and another person with an interest in his estate will have to get witnesses to testify in court that it's really all in your handwriting. This is not necessarily all that difficult to do, but can be a problem if there's someone out there who might want to challenge you. And a properly drafted will Most of the problems in proving it up to court can be avoided through the use of what is called a self-proofing affidavit. That's simply an affidavit attached to the will in which the witnesses swear, and you need two of them, not one, even the notary, just two, you need two. Swear that everything was done correctly at the will signing, that the witnesses watched the testator sign, they're over age 14, the testator was of sound mind, and so on. The advantage of this is that the will is then considered by the court to approve itself, and no testimony is necessary to have it approved. In Texas especially, since we have very progressive probate laws, this is a quick and easy process. Honestly, it really, probate hearing ordinarily takes 10-15 minutes. It's not that difficult if you've got a good document to work with. So, a colleague of mine once said to me, though, that clients will ask him, why should I pay you when I can get a trust online for $400? And he says, well, you can get a wife that way too, but I wouldn't recommend it. And finally, I will let you know a little secret. Lawyers that handle probate matters actually like people who use these former legal Zoom wills, because I've probated quite a number of those myself and can attest that every single one of them, without exception, has had something wrong with it that makes it more expensive and more complicated to probate. I've talked to other probate lawyers about this, and it's like, yeah, you know, this could have been really simple, but, you know, they used the wrong word there, and it has these implications, and somebody else is arguing about that. It's really amazing how it happens. So it makes the process more complicated and expensive. I do understand, okay? I try to be responsible in spending money myself, and I look for bargains whenever I can, but saving a few $100s by using a form will, in my experience, could be wrong, winds up creating a lot more, costing a lot more money, not to mention time, when the will is actually put to use. So we could talk a lot more about features of wills and what they can and cannot do for you, but my time is limited. And before, I'd like to take a brief look at a few other techniques used in estate planning. Number one is I hit the wrong button here. Revocable trusts. First is a lifetime revocable trust. You've probably heard a lot about this technique because there's a lot of advertising about that. This is where you place all your property into a trust and can take it back at any time. The reason, by the way, you do this, you know, why is it revocable? I mean, why not make it irrevocable? The problem is that's a taxable transfer for tax purposes, and you're creating an entity that is its own entity and has to file its own tax returns. So it's a lot more complicated. Revocable trusts are that way because they don't cause any tax issues during your life. You still file your taxes the same way you do, and only have to worry about irrevocable trusts when somebody passes away. So first thing you do, a good thing about them is providing for the incapacity of a spouse. One time, you know, sometimes you get to a point where one spouse can't act for him or herself, and you'll have property or investments that need management. Without any planning, you generally have to go through guardianship proceedings, which are expensive and difficult. One way to handle this is through placing your assets into a revocable trust, which means you and your spouse trustees. And if one spouse becomes incapacitated, the other can act as trustee to manage the property alone. This is sometimes helpful where, for example, properties held in the names of both husband and wife might have to be sold or investments need to be managed. I once had a lady consult me and had absolute panic. Her father ran a small business and was in a motorcycle accident resulting in him being in a coma. And they had payroll due the next upcoming Friday. And there's nobody that could sign on the account. He hadn't really planned for that. The only way, since he had no planning in place, the only way to do this would be to really get up and go for a temporary guardianship and ask for an emergency hearing, and that can be extremely expensive, and it's not just the emergency hearing, it's all the ramifications of that sort of thing that you go do down the line. The follow-ups you have to do with the court, the reports you have to file, the closing of the guardianship. But just a little planning in place, a lot of that stuff can be avoided. So, there are some other ways of accomplishing this as two powers of attorney, which I'll touch on as we wind up in a few minutes. There are two other things that I recommend to people if they want, for estate planning for revocable trusts, to think about. Number one, and by far the top reason, is if you have any real estate in other states. And that doesn't just mean a condo in Aspen. It can also mean fairly small mineral interests in Oklahoma or Louisiana. That, you know, you get a check for $12.80 every quarter because of these things, and then you figure out that when somebody passes, oh my goodness, we've got to have an ancillary probate proceeding in that state just to transfer that property because it's real property. And those ancillary probate proceedings for a will are always, in my experience, having had to have clients do those a few times, every blessed time, it has been literally twice as much as I thought would be anywhere close to reasonable. So, in those cases, I always recommend look into a revocable living trust. Also, is the second thing is the question of privacy, and lots of, you know, some people are really uncomfortable with the idea of having a will that is going to be a matter of public record when they die. Now, in reality, unless you're like Michael Jackson, nobody really cares. People are not going to be looking up your will when you die. But there are situations that I talk to clients about, like, well, you know, if you're, let's say, oh, we've got 4 kids. One of them has a drug problem, though, and we want to make sure that that person has funds protected for him so that he doesn't spend them all, but the other 3 are fine. And they don't really like the idea of that big public. Well, maybe in a case like that, or particular family circumstances that you don't want publicized, that's a good time to think about putting a revocable trust in place instead of a will. There's also a situation where you could, talking about sheltering assets, I have that on one of the points here. That's a particular circumstance in which if you have one spouse that is particularly vulnerable in terms of potential liability, like you have, say, a husband or wife is a physician and is concerned about potential malpractice, and you can do things by like reallocating assets between the husband and wife so that the vulnerable party has the exempt assets, like the house and like pension plans, and the other party that is not as vulnerable to liability has the unexempt assets. That can be a good planning technique to try to minimize potential liability, but it's really kind of a very niche thing to talk about. So, tax aspects, I mentioned that about it being revocable. It does not affect at all your tax situation. And finally, avoiding probate is something that a lot of people like the idea of, that it can just smoothly pass on someone's death. I think we mentioned that before. I think it might have been one of the talks we had before was saying, well, what do we do between death and probate, right? Before somebody dies, we've got powers of attorney. After somebody dies, to deal with the property, we've got the executor of their estate. But, as I said, the executor doesn't have any actual authority until the will is probated. What's done in the middle there? Well, if you're in a particular situation where you want to make sure assets are readily available and managed, you might want to think about going the revocable trust route, because the successor trustee, be it the surviving spouse or be it a child, can take over immediately upon the death of someone else. So that's the avoiding probate aspects of this. That's a positive. But I'll also give you some of the negatives. Oftentimes I see this, you set up a revocable living trust, and it's beautifully set up, exactly the way the person wants their estate handled, but oh my goodness, they died and they never got around to moving their property into it. And oh my golly, we have these accounts. In fact, this is an actual case I was dealing with a couple of years ago, where he wanted his accounts to go evenly to his kids, but he left beneficiaries on the accounts and didn't move them into the trust. And so one of them got a whole lot more than the other ones, and they were bad, and they sued. And we spent a year litigating that thing, and fortunately one of them came to me at the end of the year and said, I just wasted all this money in the lawyer, now we understand. But it was something that could have been entirely avoided had this been set up properly. But that's the thing about a revocable trust. For it to be effective, it costs a bit more upfront, and it has to be followed through upfront. for it to be effective down the road. And I talk with other attorneys, and they're saying, you know, that's maybe 1% of the time that they'll see that when somebody dies, that it was all set up that way, because it's a bit more complicated. So there is a downside to that, as well as an upside. Now, I'll briefly talk about irrevocable trusts and their uses and goals. One of the things that was talked earlier was about charitable remainder trusts. That can be useful in tax planning, but it's honestly mostly for people that have significant estates to where they could really use some major tax planning. Or an irrevocable trust, by the way, is with the grantors or settlors or trustors. It's kind of silly, we have like 3 terms for these things, and they're all derived from Latin. Can't get the property back. They're used for specialized goals. Another thing that I often see happen is you may want to set up a fund for somebody that is has special needs and wants to continue qualifying for government benefits. Well, if you give them a bunch of money, that's going to kill their qualification. But if you set up a special needs trust, which has provisions paying attention to that requirement up front, then you can help provide for that person, provide their extra needs, and make sure that they get all the benefits they're entitled to. There are all sorts of different types of irrevocable trusts for different purposes, and it's all just completely customized to each individual family's needs and desires. So that's the tax aspects, of course, of irrevocable trust. I mentioned earlier that you have to, it's a separate entity. It's like a corporation or an LLC. It files its own tax return. That's a 1041. And has to report income. Oftentimes this can flow through to the beneficiaries and not be really expensive, but has to be taken in mind when setting it up. Now finally, I just want to go through real quick the other estate planning documents that everybody should really have in place. One of them being a durable power of attorney, or nowadays we call it a statutory durable power of attorney because it's a state form. What these do is allow you and your spouse to allow the other spouse to act as the other's attorney, handling assets, transferring real estate, managing investments, and the like, if one spouse is so incapacitated that he or she cannot act for him or herself. The reason they're called durable, by the way, if you ever wondered, is that a regular power of attorney ceases when somebody becomes incapacitated. So if I just gave somebody a power of attorney and said, you're able to access my bank accounts, if I'm in a coma and in the hospital, that is invalid. A durable power of attorney specifically says that it continues to be valid, or sometimes becomes valid, when somebody's incapacitated. So that's an important thing to have. Also the second one, medical power of attorney. Allows you to name who will make medical decisions for you if you cannot make them yourself. Ordinarily, a hospital will ask you to sign one of these upon admission, but in case you're not able to sign one, it's a good idea to have something already available. And of course, also what goes with that is a Hipaa authorization. A lot of people rate that HIPAA. That's one of my pet peeves. It's actually the Health Insurance Portability and Accountability Act. And in that act, it specifically states that a Hipaa authorization must be its own document. So even though somebody may be okay with it if it's in a medical power of attorney, you really should have a separate document authorizing these. Like with the medical power of attorney, yeah, you're going to sign it when you go into the hospital, but what happens if you're, say, in a coma and can't sign something? You should have something available to do that. Fourth, the directive to physicians. I think we've touched on that already. Lots of people are considered about the possibility of being in a coma and kept on life support forever, causing a lot of heartache and draining a family's resources. A directive to physicians or a living will is a document that essentially states that you do not want to be kept on life support if you're in a coma, or you do, and there's absolutely no hope you will recover. There are safeguards in the document required by law. And I'll mention a case, though, that is not necessarily as simple a decision as it used to be. We always used to think that if you're in that situation, you're going to be kept alive forever and a day by the hospital because they don't want to be liable for something happening. So you need that. Well, in reality, after, since about 12 years ago, a doctor's committee of a hospital has legal authority to determine whether this health care will be removed from somebody that is terminally ill. And I attended a presentation a while ago about an interesting case where a fellow in his late 40s was on life support, and the hospital's committee said, we're going to pull him off that life support, he has no hope. And the family got a temporary restraining order and an injunction against the hospital, keeping them from doing that because they didn't believe it. And the guy recovered. He eventually recovered full function, which is, I'm not saying that's the most common situation ever, but it's something to be considered that which way you go in a directive kind of depends upon your state of life and what your beliefs are. And I'll also add about medical power of attorney and directive to physicians. For many people, like ourselves in this room, there are specific Catholic versions of those that we can use that specifically reference the tenets of the Catholic Church, if that is something that makes you more comfortable in making sure that you're adhering to them. A lot of people like that option, and it's good to be thinking about that. Finally, I'll just look at a couple of things real quick. A declaration of guardian is very simply, if you ever need a guardian appointed for you, you probably want to name who you would want, and sometimes who you don't want. There may be people in your family that might want to take advantage of this and obtain money from somebody by being appointed their guardian and say, no, I really do not want my brother-in-law Fred ever appointed to do any of this stuff. You can put that in there. And finally, the appointment of agent for disposition. I think I mentioned that earlier when Chris was talking. I've run into the situation myself where this was absolutely necessary. And so I do that for all my clients now. It's just very simply the only thing that bridges your death when all these powers of attorney end, they're no good after death, and between an executor being appointed, that gives somebody authority to sign off on and make decisions about your disposition. It's a good thing to have in place. So, I think I hope I've given you a few things to think about. And I'd be happy to answer any questions you might have.
Mike, if you could provide a little bit of color. I understand that the stretch IRA is no longer something that is available. So the maximum, after you die, the maximum period of time in terms of distribution from an IRA is 10 years.
Right.
So basically it's a maximum tax plan.
Right.
Can you talk a little bit about utilizing a charitable remainder trust to mimic a stretch IRA?
Yeah, absolutely. And that's the thing also about something like a stretch IRA. You know, as I said before, when you have this qualified money, it's going to, if you don't have any provisions for it in your will handling it, what you're going to do is have a lump sum hit you or hit your ears, and they're going to have to pay high rates on tax on that full amount. You're not going to be able to stretch it out over time and pay tax at lower rates. You can accomplish the same thing, or better, really, if you can put that, give that IRA over to a place like the County Foundation, right? And you can put that into a trust during your lifetime if that works with your overall financial situation, and get certain, as I said, charitable deduction benefits right now, and also reduce the potential tax load on your beneficiaries. So that can be a really good technique to think about.
You can also use it in a testamentary fashion to benefit your children.
Right. Yeah. So yeah, that was something actually I added to my wills a while ago. There's a whole, there's like 2 pages of stuff about if there's qualified money in the estate, here are your options, the trustees' options to distribute it according to minimum required distributions over the next several years so that you can take full tax benefit of it. Most people look at that and go, what in the world is all this? But it's just kind of, it's just there in case it's needed. It'll be okay. Lisa?
Hey Mike, how much should just a normal family expect to budget to create all of these documents?
I can't speak for other attorneys, obviously. Really, when we're talking about, if we're talking about a will, I'll just throw this out, will-based plan with all the documents, and by the way, there are a bunch of other documents I provide just routinely that I haven't mentioned, that are like, for example, was it Chris was talking about? Was it Chris talking about funeral planning? Yeah. He said you should get your wishes down, funeral list, but I have that document and it's up available on my website for free download for anybody. It's called Funeral Instructions and Disposition Instructions that you can download, put on your computer, fill out an Acrobat if you want, print it out, sign it, good to go. I asked him to look through it and see if I was missing something or if I could fix that better. But for that sort of thing, probably around $800. And I like going with flat fees because when I talk to some people we have to go through everything time and time again, make lots of changes. I don't want to be on the clock for that. I want people to be comfortable and say, all right, some people it's like, no worries, okay, we got it done, we'll get it signed and off we go. And some people are much more complicated, and I want people to be comfortable with that. With a revocable living trust, we're probably talking more like $1,250, $1,300 because it's more complicated to put together. Yes?
Good question. Once you make your will, and I've heard different opinions on this, should you give your children a copy of that will or just keep it with your lawyer? Is it not a good idea to give out copies before you die?
Oh, I get to give the lawyer's answer to everything. The lawyer's answer to everything is, it depends, right? In most circumstances where it's kind of a standard situation, I think you should probably give copies of these to people. Let people know. When I do wills and estate planning documents for people, I always give them a flash drive, which contains copies of the signed documents on the flash drive, and say keep those originals safe. And then you can, send somebody an email with the flash drive with the copy of the will on it if you want to do that.
But if you change your will later on, somebody can't come up with that old will and say.
That's right. Well, one of the things about the will does is always revokes previous wills. So if I have a 2018 will versus a 2020 will, the 2020 will trumps that.
All right. My other question is this. If a power of attorney, that ends when the person dies. Like
yes.
He's got a 92-year-old mother. He's also the executor. Who, until that gets probated, does he have freedom to pay for her funeral expenses? And, how does that work in that limbo period of time?
Ordinarily, what we want to do is pay for the funeral expenses because that and expenses of last illness are what are called a priority claim against the estate. So when you get full management of the estate, that gets paid before anything else, including any creditors or anything like that. So you get up front, the funeral expenses of last illness are reimbursed immediately.
But does he have the authority to do that if he's not the executor as immediately?
It's technically a claim against the estate. So if he does that, he's like any other creditor, except it's a top priority claim that gets paid first, technically speaking. Now, oftentimes they'll still have access to their accounts, and it's really not that big of a deal. If you can pay out of the accounts, it's okay to do things informally. Of course, even if you're not officially the executor, you want to go secure the property, right? I've got lists that I give clients about do this and this and this. Secure the property and take care of it. But you don't have the legal authority to do certain things, and you want to get that done as quickly as possible. Thanks.
Yeah,
Yes.
Who makes the best executor? Say you and your spouse died at the same time. Is it like an adult child that would be the best, or is it? I guess is this it depends answer?
Yeah, it depends. It also depends on your stage in life. If you're a lot older, if you're older like us, maybe it's not as good idea to name a sibling or, heaven forbid, somebody in an older generation because they won't be able to handle it. You might want to name a younger generation, but when we're younger and our kids are in their teens, for example, there's when you might want to think about, oh, let's name a sibling or something for a while then. And then the kids get older and you can see, oh, they're responsible. I can name them. So, again, it all depends upon what your family's like. And who's the one, you could have a kid that's just kind of has never figured things out. And then you've got, at age 30, and then you've got one that's 23 and has just everything nailed down and has already bought a house and is just really responsible. And that would make more sense for that kid to do things. It all depends on your family circumstances. Roger.
If you have alternate signer and checking or say, can that person continue to have access to those funds after your death?
They can. It depends on how the account is held. Sometimes it's they're joint accounts. Sometimes it's just a named signer. Sometimes you have to look at the account and say, we need these funds to keep the lights on. And maybe it's not a good idea, just between you and me and the walls. Maybe we shouldn't tell the bank that this person is deceased because they'll freeze all the accounts and then we're going to be stuck. You want to make sure that you're taking proper care of the estate for the beneficiaries and do it honestly, of course. Yes?
When my father passed away, I changed the property to my mother's name.
Mm-hmm.
And I think the clerk told me that it has already been probated through the courts.
Okay.
And is there any process if my mother passes away that we have to go through to later on to sell a house?
Your mother is still with us?
Yes.
And your father's passed away, but title was transferred to her?
I did.
Then that should be just fine. You should be okay. When your mom passes, if she has a planning in place, they name you as executor, and then you'll have full authority to deal with the house and do it where you need to. Yeah.
Mike,
Yes.
How long does it take for the will to go through probate?
Yeah, that's a good question. Back in the ancient days, back in like 2019, I'm sorry, she said, how long does it take for a will to go through probate? Okay? Now, back in the days of yore, like in 2019, you could file a will for probate and usually get a hearing within a month. And you get the hearing, and you get your letters, and then you'd have a 90-day period where you'd have to notify creditors, send copies of the will to beneficiaries, and do an inventory appraisal and list of claims. And frankly, that's all you really need to do for the court. You're done with your court responsibilities. In today's environment, at least especially in Dallas County, it can take 4 or 5 months. Just because they're so backlogged, and it's really, we're really hoping we'll get this thing figured out, but it's been annoying for quite some time. Even with Zoom meetings, it's like 4 or 5 months before we get here these days. Mark?
Does probate have to be in the county where the individual is living, or can it be done in another adjoining county?
Yeah. Does probate have to be in the county where the individual is living, or can it be in an adjoining county? Technically speaking, it's supposed to be where the individual had their principal residence, but can also be in a county in which the individual had a significant amount of assets. So you can do that somewhere else. Judge Copeland tried an experiment a few years ago where he allowed, this is Collin County, they allowed what they called is kind of consent venue, where you can go and probate a will in Collin County, even if the person wasn't in Collin County, but that didn't last very long. People complained about it, and so you're really supposed to be in a particular county that you died in or that you have a residence in. And that can be problematic because some counties are more difficult than others to get wills probated. Collin County, honestly, is really easy, really smooth. Dallas County can be real persnickety if there's some issues with the will. Same with Tarrant. But you need, if you know how to navigate these things, it doesn't have to be that difficult, and you've got good documents in place. So, yes.
So I have a down-syndrome nephew,
Yes.
and I don't have children of my own. Are you saying that what I did right now is I signed one of my investments over to my dad, my brother, to take care of him because I didn't want him to lose his governmental
Right.
that he gets. Are you suggesting that I should change it to a trust instead?
I would actually, yeah. She's saying I have a Down syndrome nephew, and I moved some assets over to your husband's brother, your brother, to be able to help take care of him, so that he wouldn't be disqualified for benefits. That's just perfect case for a special needs trust. And I'm sure your brother's a great guy and he's trustworthy and all that, but technically speaking, he doesn't have any legal obligation to take care of your nephew with those funds. And I'm not saying that will be a problem.
It's just like when we go through our audits, they always say it's on the person's position as to whether you would commit fraud or something.
Yeah, exactly. Yeah,
I get what you're saying.
you know, one thing I talk about with these documents all the time is it's, number one, also, people talk about naming executors and trustees, and they're always worried about, oh my goodness, if I name this person, the other person's going to be mad. An executor or trustee is a job, it's not an honor.
No kidding.
And these documents are not intended to be, that's what people need to understand. We're not doing these because we don't trust other people. We're doing these to forestall arguments in the future as much as possible. Maintain family harmony as much as possible. My wife and I were extremely blessed with our families that, you know, when our parents died, everything went smoothly and we're all still close. But I want to see that happen for everybody. But I see too many examples where it's not, where families come apart. So.
What's your opinion of naming like two co-executors versus one executor and a backup executor?
I'm sorry, I'm chuckling because that's been one of the banes of my existence for the last year or two. I've been dealing with a case where mom named, okay, I'll tell you this case, this case. Mom had two sons and a daughter, and a couple of daughters. And she named the two sons as her executors. And it sounds nice, but it turns out they absolutely hate each other. Oh, they hate each other. And it's been, I can show you a line of emails as long as me from these brothers to each other. Just all they can do is snipe at each other. They think that each other, you know, they can't stand each other. And it's been a nightmare to deal with this thing. And we still haven't gotten it resolved because the attorney for the other brother recently died. And so I'm not sure what to do. I don't feel like I should contact him directly. That wouldn't be right, but what do? I died. So, you know, I've still got like $4,000 sitting in my trust account that I just want to get, pay out to these guys and get rid of. But we need an agreement to do that. And it has been a nightmare. So I'm really not fond of naming co-executors or co-attorneys in fact, that sort of thing.
Having a backup executor is...
Oh yeah, of course. You always want to have backups. You always want to have successors in place. I always recommend at least 3. But in case somebody can't act.
I'm going to ask a question at the beginning. It's like my situation, but I'm not sure which one. People say that it was a lot of siblings.
A lot of siblings,
A
yes.
lot of brothers and sisters, but I'm not sure which one of those are. Okay. Yeah, he has a good question.
Oh yeah, Tony, yeah, we were talking about what you mentioned.
What about having lots of siblings
And what somebody's wishes are. And
Yeah.
frankly, I was saying to Jane, just as you were talking about that, I have a standard directive to positions form, and I have a Catholic version of that I've used for years and years. And that really made me think that I think I'm going to go back and spend some time adding stuff to it and customizing to it, because sure, it's great to have somebody that has the legal authority to make these decisions. That doesn't address family harmony on what those decisions are. And if, I'm going to do some research and come up with a better form, because if his, mom, right?
Mom and my 5 sisters.
Yeah. But if mom had a more extensive directive, not only saying what she wanted for end-of-life issues, but for general standards of care, here's what I want and here's what I don't want. in detail, that might be helpful in getting some harmony among the family, knowing what mom really wants. So that's something I've got to do some research on and come up with a better form. But, you know, I like telling people that I learn something every day. Being a probate and estate planning attorney, I have to learn something new every day. I run into situations I've never seen before. And so I figured one day down the road, I want it all figured out. When I have it all figured out, I'm going to drop dead. But the way things are going, it's going to be a really long time from now. So, okay, so
one more question? We have time for one more question.
I just wanted to know, when you asked on when you said about the IRAs when they pay out, they have to pay out over a period of time, now 10 years, is that the same for traditional and Roth?
no, Roth IRAs are different because they're post tax.
That's why I just want to make sure.
Yeah, no. Yeah, Roths are, man, if you've got a Roth and you've got a bunch of money in it, you're in good shape. That's terrific. Yeah, you don't have to worry about tax implications of that. Okay, Mike.
No, go ahead, one more question.
Oh, yes.
Jewelry. Mom never wanted to identify, and tons of diamonds, never wanted to identify who she wanted to give certain pieces of jewelry to. And now she's on hospice.
Right.
What's the best way to distribute that? It's supposed to be equal distribution amongst the siblings.
Again, it all depends, and I'll explain why it depends. If everybody's in full agreement and everybody's really comfortable with each other, just getting together and saying, I'd like this, and you like this, and you can get it all sorted out in one, should be able to get it sorted out in one sitting. If people are a little bit contentious about it and a little concerned about actual valuation, you might be worth having somebody give some valuations for the pieces of jewelry and divide them up in terms of what their value is so that everybody's comfortable we've gotten an equal share. Yeah. Okay. Thank you all.
Thank you very much, Mike. So the lawyers always get the most questions, right? So it just kind of happens. Just as kind of a segue, I got a piece of advice from a lawyer one time that I'll share with you, and it really seems to have worked out well. My father has only taken one, and I mean one, piece of advice from me, and it was this. When a person dies, okay, they want to be fair about their estate, and a lot of times people will divide it equally among their kids. Because what happens is when you die, money becomes love units, okay? So if I got $5,000 and my sister got $4,000 from the estate, that means that I got 1,000 more love units than my sister, right? So what I talked to my father about at the advice of a lawyer was sit down and write your kids a note. Okay, each of your kids, not the same note, 3 times for your 3 kids. Individual note telling what that child means to you. And let that, as opposed to money, be the way that you're going to be remembered by your children. Okay, does that make sense?